Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don Ross, thank you for coming on the show this month again.
Thank you, Jim. Appreciate you having me here.
So the viewers that have not heard of you, which is probably very few, tell us a little bit about yourself.
I'm an attorney in Naples. I've been a member of the bar since 1981. I have a degree in taxation. I specialize in real estate law. I'm one of the shareholders in Downing Fry Realty. Been their corporate counsel since 25 or so years ago. Own Ross Title and Escrow. We're on the corner of 6th Avenue North and 41. I have 7 closes. We do a fair amount of volume. The people have been with me anywhere from 30 to 5 years. So a nice, tightly knit group. And we have our own law firm. So we've been doing it for a while.
Yeah, I know our clients are very happy, and you return phone calls, and your closing agents return phone calls.
Try not to be rude. You got to return phone calls.
Yeah, we're in a service business.
Yeah, absolutely.
We?
We're in the people business.
So what I wanted to do today was go over a bunch of disclosures because, you know, with a lot of new agents coming in the industry, and there's a lot to learn. These things are prepared really from attorneys, and they can get complicated. So I just wanted us to go through some of them, kind of clarify some things so nobody gets in any kind of lawsuits or make mistakes, because nobody does it intentionally. It just has to be filled out properly.
It has to be filled out properly. You're absolutely right.
So let's start the Homeowners Association disclosure.
Well, the Homeowners Association disclosure is dictated by Florida Statute 720. And they have a definition of what is a homeowners association, and one of the key ingredients is their ability to lien the property for maintenance if the homeowner does not pay their maintenance. So we run across the occasional ostensible HOA, which really is not one pursuant to the statute. But the disclosure was enacted into law, Chapter 720, I don't know the exact date, but 5 to 10 years ago, to better serve the public, to give them a heads up on what the maintenance is, whether there are any special assessments, are there any land leases relating to the clubhouse or common elements. And it also, at the bottom part of the form, has an indication that if you want more detail, you can either get a complete set of the documents from the public records or the management company, and they urge you to read these before you sign the HOA summary disclosure. Now, by law, the Homeowners Association disclosure has to be presented to the buyer before they sign the contract. If it is not, in most realtors, they'll put it with the entire contract package and they give it to the buyer for execution. If that does not happen, if the Homeowners Association disclosure is given 3 days after the contract is executed, the buyer has 3 days to cancel the contract. If you give the disclosure with the contract, they have 0 days. So giving it with the contract is extremely important. I know of one case where that was not done, and the buyer used that as an opportunity to cancel the contract, and the owner sued, saying it should have been included, you cost me the deposit, which happened to be $120,000, and the insurance company, just to get it off their back, ended up paying $40,000 to settle the matter. So presenting it with the contract for all the new realtors out there, or the owners who are trying to sell their property, is a must. You really should do it.
What is part of that disclosure? What are we disclosing? What fees?
The quarterly maintenance, if it's quarterly, any special assessments, if any have been made, and if there's a land lease. And then there's paragraphs after all that say, for more detail, you can go to the public records. You can order a full set. Pelican Bay Foundation is probably this high. I mean, some homeowners association documents are actually quite interesting. They'll have use restrictions in them. Others are just a total waste. I wouldn't bother, but if there are use restrictions, I want to know about it.
So on this homeowner's disclosure, that has a homeowners or condominium homeowners association.
It's not a condo. A
It's a
homeowners
homeowners,
association
right.
is a separate statute, is a separate
Right.
corporation.
Okay, so if there's, we put the fees on, right?
Right.
Okay, and if there's a country club fee, we put that on there?
No.
No.
No. Here's where people get hurt.
That's
and,
what
and realtors in their commendable effort to be helpful to their client put down, the capital contribution, the resale fee, the club membership fee. Some will combine the homeowners association, like in Pelican Bay again, for example,
Right.
just using them as an example. If you're buying in the Remington, which is a condominium,
Right.
they'll combine the condominium fee and the homeowners association fee on one form.
Mm-hmm.
That's wrong.
Mm-hmm.
That gives the buyer the opportunity to cancel the contract. That could get the realtor sued. It doesn't make any sense.
Mhm.
I mean, you would think that providing the consumer more information would be applauded rather than penalized,
Right.
but that's the law. It doesn't make sense, so you can't wing it and think, well, this is a good thing and just do it.
So you would put that on two separate forms?
The condos are entirely separate.
Right, okay.
So if we stick to HOA, I'll
Sorry.
hit the condo.
Sorry.
No, it's your show, Jim. Don't worry about
Right.
it.
I'm just-
But this
right.
happens all the time.
Exactly,
People
right.
confuse condos with homeowners associations. Homeowners associations, you have to give this one-page disclosure.
That's it.
Period. End of
Right.
story. You
Right.
do not have to give them any documents at all.
Uh-huh.
Okay, this is a statutory requirement.
Right.
And the timing is critical. It has to be with the offer,
Mhm.
or the buyer can cancel. If it's with the offer, they can't.
Right.
So that's important. Condominiums, which in the Naples contract
Right.
is the standard I of the contract, you have to give a bunch of documents.
Mhm.
You don't give a summary page,
Right.
you give a bunch of documents. So with homeowners associations, you give the one page and no documents.
Right.
With condominiums, you give a stack of documents and no summary page.
Mhm.
You're not required to give a summary, for example, showing what the maintenance is, what the special assessments are, whether there's a land lease. That's not required for condos.
Mhm.
Does it make sense? Absolutely not.
Right.
You think they'd use the same formula, but they don't.
Mhm.
So if you just try to remember they're separate corporations, they don't make sense. You give them the bare minimum of homeowners associations on that form.
Right.
That form is like the 10 Commandments. If you try to add an 11th commandment,
Mhm.
you're in trouble.
Right.
You could end up being sued. Does it make sense? No.
Right.
No. If you want to tell your buyer what the resale fee is or the club fees are, you do it in a cover letter.
Mhm.
Or you can put it in an amendment to the contract.
Right.
You can put it under other terms and conditions in the
Mhm.
neighborhood contract. Do not mess around with the HOA form. Fill in the blanks with the exact information. Do not combine two homeowners associations on one form. Do not combine a condominium with a homeowners association on one form, because some condominiums will pay the HOA fee.
That's right, they do.
And a new realtor will throw it on the HOA form.
Mhm.
And they don't bother to separate it out. So I know I'm being overly picky, but there's a lot of cases out there that really hurt people if you don't do it exactly
But
right.
we're not allowed to fill out this form anyway.
You let the homeowner do it.
Fill it right out.
Anything with a homeowner's handwriting on it is better than your handwriting
Exactly. You're exactly right.
Because you're relying on their information anyways
Yep.
if you're filling it out.
Mhm.
If anybody's going to make a mistake,
Let them make it.
let them. You advise them to seek counsel. You
Mhm.
can point out that there's more information in the public records or from the homeowners association if you have special needs,
Okay.
if you have pets, or you have you want to put up a basketball hoop. Are there any use restrictions? So you can call the management company directly if you're a buyer. But the homeowners association is one thing. If you want to go to the condo, we can hit that whenever you're
I'm ready.
Condos, again, in NABOR, we have these title standards. H is for homeowners association, so standard H gives you all you need to know, but we're afraid to ask for homeowners associations.
Right.
It doesn't go into the detail on don't give them too much, like I just did.
Right.
I is condominiums.
Mm-hmm.
Now, this has been around forever, and what the seller is required to provide to the buyer is the declaration of condominium that creates the condominium.
Right.
It has use restriction in it, so I'll tab the use restrictions and highlight pets and when family visitors are allowed to use it, when non-family visitors are allowed to use it, what kind of car you can leave there, anything that was that would pertain to the day-to-day use of the property. They have the bylaws of the condominium association, which bore most people to tears. How to hold a meeting, how many members on the board, that sort of thing. Then they have the articles of incorporation of the condominium association. Of the three, it's the declaration and the use restrictions that tend to be more customized. All these documents are going to be reviewed and approved by the Division of Land Sales and Condominiums in Tallahassee. So it has to have a certain uniformity to it, where the custom and work is the use restrictions.
Right.
So that's the first three things in Standard I for condominiums. Then they have rules and regulations, which I always tell my buyers, you want to read these. This is your day-to-day use of the property. Frequently asked questions, which is a nice shorter version of the most common issues people tend to have. The year-end financial statement, which these days is interesting.
It's the most recent one.
Most recent one available, and 2018 should be available at this point. And typically you're looking at reserves, and I look at accounts receivables. And then I go beyond that. When I talk to my buyers, I suggest they might talk to the management company and ask, because sometimes reserves will be a little low.
Right.
They might have just spent a lot of money replacing the roofs, repainting the condominium, redoing the parking lot, redoing the pool area because of Hurricane Irma.
Right.
So sometimes it's low, but you've got brand new everything with a useful life of many years, so it's not as much of a concern. And then I explain to my buyers that they have an annual meeting, and as part of that meeting they get to vote on whether they're even going to have reserves, and if so, do they want to get more current estimates on what it would cost to redo the roof, repaint the place, redo the pool, so they can calculate what the reserve should be from this point forward. Don't keep working off of an estimate from 10 years ago.
Right.
Because those prices are way off, especially roofs.
Exactly.
Okay, so we have the declaration, we have the bylaws, we have the articles of incorporation, rules and regs you want to read, frequently asked questions you want to read, the year-end financial, do we have reserves? And there's usually a phone interview, and I always tell people, ask about Irma. I mean, is there still issues going on with the insurance company? Do they have enough money to pay the deductible on any insurance claim?
Right.
You don't want surprises. People from up north think everything's all fixed already.
Right.
I mean, I would. I mean, but you and I know that we still see tarps on roofs, and we're still seeing, people are still discovering issues that they didn't realize existed after the hurricane. Like with roofs, it seemed fine, it didn't leak, but when you go up and look at it, they might have shifted a little bit, the tiles. So there is no summary, it's just a bunch of documents, and I suggest to people, have them emailed to the buyer and their attorney. Don't sign the condominium receipt until they're reviewed. 2 out of 3 times they're incomplete when I look at them. So that's why I say don't sign until I've seen it and tell you everything's there. I looked at a set this morning and we were missing the year-end financial statement, the frequently asked questions, and there's a thing called the governance form, which the state requires, which is sort of a summary on how you hold meetings. So I went through it quickly, and I told one of my closers, find the file, let the client know, don't sign the receipt, we're missing these 3 things, which we emailed everybody, and they're going to get them to us.
Well, that's a lot we covered there. Let's take a little short break and talk a little bit about the York Group here.
Sorry about that, Jim.
And we'll be back in 1 minute here, so I can catch my breath. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, we're back. So, Don, tee it up.
Deepest apologies.
Tee it up again. Tee it up again here. So,
Sorry about that, Jim.
That's okay. There's a lot of good knowledge
Well,
there.
I get that all the time.
Exactly. So it's better to be
drives me
long-winded
a
than
little
short-winded,
crazy.
right?
Yes.
So
Sorry.
let's talk about the CDD form.
This is something we use in Collier County with the Naples Board of Realtors contract. CDD is the Community Development District. When a community is being built,
Right.
the developer may sell bonds to build the roads and the infrastructure necessary to sell the individual lots. That bond gets incorporated into the tax bill the homeowner receives every year, and you pay a portion of it off with each tax payment that you make. Some have a payoff. It might be payable over a certain number of years.
That's right.
And there's a payoff. There's no statute that requires the disclosure of this, but I live on Marco, and we had mandatory sewer hookup, and it was approximately an $18,000 payoff. And out of fairness to the consumer, the Naples Board of Realtors Legal Resources Committee decided, and I think rightfully so, let the buyer know if they're assuming a debt, essentially, that there's a payoff on this community development district. And that way they can adjust their offer accordingly.
So a buyer has to see this with their,
Yes.
the additional cost is going to be on their tax bill because it's collected through
Yes.
the tax bill. But it's not required to show them the balance, but
No, you have
We
to
want
show
to show
that,
the
and again, you have the owner write it in their handwriting.
Exactly right.
And sometimes we get phone calls on what it is, and we email or check on the appraiser's website, and we get to see what it is. Sometimes we have to order from whatever city the property happens to be in. But that was the cause for this particular form. It's tied to a particular paragraph in the Naples Board of Realtors contract.
Right.
That don't sign this contract if you're part of CDD/MSTU, which MSTU stands for Multiple Service Taxing Unit. Pelican Bay is a multiple service taxing unit. They collect annually a certain sum of money in order to care for the common amenities, the meridians in the road and things of that sort. And they typically in those situations is not a payoff. It's just an annual fee. You want the roads to look nice. So it just gives more information to the buyer, and it's a good thing to have. You do not want to omit it and then have the buyer find out that there's an $18,000 payoff after the closing, because they'll be calling you saying, you didn't tell me, you messed this up, it's in the contract, you're supposed to check this block and you didn't. So as to the new realtors again, check on it. Check with your owner. Have them check with the appraiser's office. Get a copy of the tax bill. If in doubt, call whatever title company or lawyer you happen to use for your closings and ask them to verify it so that you're okay.
Because it is on the tax bill.
Yes.
So, the next form we have here is, well, inspections is always a problem. So
They are?
yeah.
Really?
Well, not always, but they, we just did one this morning for one of our listings, and it, went very well. The guy was very detailed. He was a master inspector also,
Right.
like the one we use
Sure.
for our buyers.
Yeah.
We use another one. And it went well. They found some things, or he found some things, but
Right.
it wasn't over the top. Everything was reasonable. And he didn't have a conflict of interest where he does the work afterwards, like some inspectors have a crew and they just make up things. We were talking to another agent in the lobby here at Naples Daily News, and he was talking about that.
Yes.
That,
No, you're
inspector
absolutely
said
right.
there is roof tiles missing up on the roof, and they brought the roofer out there, and he said, where? And he said, well, somewhere up there. In the
Well, we
roof
had a
there."
storm, so there must be.
Yeah, so.
I think was the logic.
Was it, so.
So he didn't actually see anything, but
That's interesting. But in our contract, you're now supposed to list the items, so maybe you could.
it goes with the buyer's election seller's response form. These two forms together are there for the assistance of the realtor. It's a guide on how you notify the seller that you want a repair or a credit, and specifically what the heck you want repaired. In the past, before we had this a list of defective items, which requires you to write line by line
Right.
specifically what is broken and what you want fixed. Before that, the custom seemed to be they'd take the summary page out of the inspection report and stick it in the back of the buyer's election seller's response form, and they'll check off the remediation box, sign it, and shoot it over to the listing agent. And the summary page could have things on it like, the air conditioning differential is off 3 degrees. It doesn't fit manufacturing specifications. We recommend that the air conditioner be inspected by a licensed HVAC company.
Right.
So they're recommending more inspections.
Right.
They noticed an issue. They're not an expert in that particular field, so they're recommending get the expert to check out whether or not the air conditioning differential, in my hypothetical example, is a result of a defect, or is it simply you need to adjust the fan speed, which I'm told is a common reason for this. And the additional inspections are the buyer's responsibility, not the seller's responsibility. So this form, I think, came from the need to get rid of using the summary as what people relied on, and making the buyer sign specifically what they want. And that way it makes it easy for the seller, who has 10 days after that,
Right.
to look at and decide, yes, I'm doing this. Sorry, this is not a defective item under the contract. Sorry, this is 15 years old, and the fair market value of a 15-year-old air conditioner is $3. So I'll give you $3. There's a lot of strategy with this. If you have a very large deposit, I've written about this. Sometimes the seller might agree to do additional work that would be deemed cosmetic because they want to look good in front of the judge.
Right.
I'm a nice seller. I tried to repair everything that was defined as defective under the NABOR contract. And not only that, Your Honor, I did all this extra stuff I didn't have to. And we'll actually say,
Right.
when we respond, that this is not required by the contract, but we're taking care of it. Something to that effect. And in some rare cases, if it's a really big deposit and we know the buyer really doesn't want to buy it, we'll add language that if we've missed anything and the buyer can point to a particular portion of the contract that makes us liable for whatever it might be, we agree to fix that too.
Right.
So sometimes, earlier we were talking about some of these inspection reports that are 200+ pages, and it's easy to miss something. It's just the sheer volume of what's been gone through, and you miss one line and you could be jeopardizing your claim on the deposit if the buyer is trying to wiggle out of the deal. So that list is a good effort to make people be specific.
I think it's a great forum.
Yeah, I like it.
Yeah.
Write it down. Don't just take a summary without really reading it.
Yeah. Well, Don, I appreciate you coming on the show, and I think this was an interesting show, like all of your shows. But going over these forums are something that a lot of people don't understand. Agents, buyers, sellers, and I think you maybe clarified it, and hopefully you helped. And I appreciate you tuning in today. We'll see you next week here, next Thursday at 1 o'clock. Thank you.